I call the meeting to order. As you note, I'm not the usual chair. Joel is having some transportation issues today, so I will be filling in, so I hope you bear with me for this. Welcome to meeting number 74 of the House of Commons Standing Committee on Industry and Technology. Today's meeting is taking place in a hybrid format pursuant to the House Order of Thursday, June 23rd, 2022. Each witness gets 5 minutes to start, and we have, I believe it is it 6 witnesses today? 5 witnesses today. 4. 1, 2, 3, 4. Yep. We'll start with Mr. Bhattacharjee. I hope I said that correctly. Bhattacharjee. Thank you.
Mr. Chair, members of the committee, if I'm ready to go, thank you for the invitation to appear this afternoon. I chair the Competition and Foreign Investment Practice at the Canadian law firm Borden Ladner Gervais LLP. My comments today are made in my personal capacity and not on behalf of the firm or its clients. I have practiced Canadian competition law and foreign investment regulation for over 25 years. I've previously taught competition law, including foreign investment regulation, at the Dalhousie Law School as a part-time faculty member for about 10 years. And I'm also currently appointed by the Commissioner of Competition as a non-governmental advisor to the International Competition Network. My remarks in the bill today are going to focus on the issue of prescribed business activities, or as I'm also going to refer to them as sensitive sectors. There's been considerable discussion, I think, both within this committee and among stakeholders, about what a prescribed business activity should be for the purposes of what the bill proposes to be a mandatory pre-closing notification requirement, which is essentially an early warning system for sensitive sector foreign investments in Canada. And as an aside, I do note that the Minister has suggested that these sectors will be reflected to some degree in the regulations to the new Act. And I do, in response, I think, to some questioning that I had reviewed in some of the other sessions, I do agree that it is preferable, by the way, to leave those sectors for inclusion in regulations as opposed to within the Act itself to preserve a degree of flexibility. But having said that, my remarks today won't really be about what should specifically be on the list or not. My primary concern before you this afternoon is really to discuss how we ensure clarity and comprehensiveness in how that list is expressed in the regulations. And I have 2 things to say about that. The first is that we need to ensure that we describe each prescribed business sector in a meaningful way. And I think certainly beyond what we presently have in the existing guidance and policies that have been issued by industry. If you look at the existing guidance, what we've done to date is set out very broad buckets with varying levels of context. And that's because that list currently is for the purpose of evaluating the application of the substantive test to be applied by the Minister or the Governor and Council in making a national security determination. So if you look at Annex A to the National Security Review Guidelines, it sort of lists 15 sensitive technology areas without a lot of elaboration, and some of those areas will include like aerospace, biotechnology, medical technology, and quantum science. And that's fine for that purpose. But for the purpose of implementing a mandatory and suspensory notification system that's going to be triggered really by tying an activity to one of these prescribed business sectors, as the bill proposes, we're going to have to make this a bit more detailed, as some other jurisdictions have done. Now, I am personally kind of a little cautious about importing ideas from other countries or regulatory regimes, holus bolus, into our policy architecture, especially in foreign investment regulation, where in fact Canada has been active in this area for a longer time than many of our major trading partners. And so there are many things that we have learned on our own that we should be quite ready to deploy. But I will make an exception here. And I'll invite the committee to review sort of what the UK has done in their approach to identifying sort of the sensitive sectors under their National Security and Investment Act. Their regime actually identifies 17 sensitive sectors, which are sort of similar to those that are contemplated in our own guidelines. But the UK government did 2 things beyond just listing them. The first thing was they had fairly comprehensive, I think it's about 50 pages worth of regulations, where they set out 17 schedules, like a schedule per sector, with definitions that are accompanied by technical detail, and then a requirement that within 3 years after implementation, I think within a three-year period after, the minister has to review the schedules to make sure that they are achieving the UK Parliament's objectives. And so that, I think, is a useful thing that they have done. The second thing that they did was, in addition to the regulations that they had, they issued accompanying guidance that actually fairly comprehensively interprets the scope of each one of those 17 schedules. And so actually, when you go to the website, you'll see that they outline like a series of even evaluative considerations that are particular to each one of those silos. And so I would suggest to you that this approach, which combines sort of reasonably comprehensive sector descriptions with the detailed guidelines, and then on top of it has a requirement that the government review the list periodically, is a good thing for us to look at in Canada. And then my second observation, this is maybe a bit more substantive, and it's to simply note that we should maintain a calibrated approach to identifying prescribed business activities as to, I think, a more reflexive one. And that's for two reasons. I mean, first, our approach to identifying sensitive sectors should be broadly consistent with the positions taken by our allies, not just in Five Eyes, which I know folks have talked about in committee, but also in bilateral relationships like our Canada-U.S. Joint Action Plan on Critical Minerals, where we are coordinating our approach to that entire supply chain to some degree with what the U.S. Is contemplating. And then my second and final point is simply that national security, it's obvious, requires a whole-of-government approach. And it's probably good to remember that though the Investment Canada Act is a way that we can assess and address potential national security concerns, it's unrealistic, I think, in my view, to assume that that legislation can accommodate the entire universe of legitimate national security concerns that may emerge and will no doubt continue to emerge in the future. And so it's really just one piece of the puzzle, which obviously is a very important puzzle that we want to get right. But again, it is just one piece. And with that, I'm done. I thank the committee for its time, and I'm happy to answer further questions as required. Thank you.
Thank you, Mr. Bhattacharjee. Mr. Hirsch, you're next.
Hello. Thank you, Mr. Chair. Members of the committee, thank you for having me participate today. I am the head of the Norton Rose Fulbright LLP Canada Competition and Foreign Investment Group, and I am appearing here in my individual capacity. And as with Mr. Bhattacharjee, my views are those of my own and not of any clients or the firm. I think I want to start off by saying that I think as a Canadian, the national security review provisions of the Investment Canada are probably some of, if not the most important provisions of the ICA from my perspective. And while it's important to ensure that we protect national security interests, it's also important to ensure that we don't do so in a way that creates an unnecessary or overly onerous burden for the vast majority of investments that are compatible with Canada's investment strategy, foreign investment strategy. And just by way of details, you know, ISED's 2021-2022 annual report indicated that over the past 5 years, only 70 investments have been subject to the formal process at all, and only 39 of those proceeded to a full review. Of those, 15 were allowed, 14 were withdrawn, 7 required divestiture orders, 2 were blocked, and 1 was ongoing. So I think it's important as we think about the best way to deal with assessing investments from a national security perspective, we also understand that the vast majority of investments are in line with Canada's foreign investment policy. Also, I think it's very important that any regime is as clear as possible, understanding that national security, by definition, involves information and not being able to share all the information that might otherwise be the case. It's important for investors to understand the rules and how to apply them. Touching on some of the areas that Mr. Bhattacharjee touched on, I think that the notion of prescribed business activities and the notion of a mandatory pre-merger or pre-implementation regime, I think that acknowledges that there are situations where it's important to be able to assess and potentially stop certain types of investments before they happen. In particular, investments relating to sensitive technology, data, or intellectual property, and especially where not taking a proactive approach might actually impair the ability to take effective remedial action. I think there's a real concern with the draft legislation that the term prescribed business activity is quite vague. As others have said, I think it's important to appropriately define this. And also, the other thing is there's also other terms such as material non-public technical information or material assets that are, again, quite vague. And it's very important that people understand how the law will apply to them, to understand as they assess whether to make an investment, what regime will apply to them. And while Mr. Bhattacharjee talked about the UK approach, I think we have a lot to learn from the US CFIUS approach. And in particular, they have adopted an approach, a mandatory regime to non-controlling investments in what they call US TID sectors or US TID businesses. And that those are businesses that relate to critical technology, critical infrastructure, and sensitive personal data. So it's important to make it very clear for people whether an investment is subject to the mandatory process. The other thing is, well, it's important to focus on the types of industries where we believe out of the gates that there could be a national security concern. That's only part of the test. There's a two-sided analysis. There's what is the industry or what activities are the Canadian business engaging in? Are those activities potentially raising national security concerns? Also, who is the identity of the investor? And I think, it's fair to say that there are some investors whose investments are almost generally compatible with Canadian interests, and there are other types of investors who may be viewed as raising potential concerns from a national security perspective. And to treat all investors the same way, forcing all investors to go through the same process, seems quite frankly to be an overly broad approach, an approach that is going to be wasteful of time, wasteful of resources. And one example, again, drawing from the CFIUS experience, they have this notion of they have foreign exempted states and foreign exempt investors, where investors who are tied to a state or country that the U.S. is deemed to be, quote unquote, a safe state or a trusted trading partner. They've so far designated Canada, Australia, the UK, and just recently New Zealand as those exempt states. And investors who meet certain criteria are viewed as exempt foreign investors, and they do not have to go through the mandatory regime. I liken it to a nexus type approach to foreign investment. You have a no-fly list, you have a trusted traveler, a trusted investor list, and you have everybody else.
Sorry, Mr. Hirsch, that's a little over the 5 minutes.
Sorry, thank
Maybe
you.
we can get to some of the items that remain in your questions during the questioning time. Mr. Jonasia next, please.
Thank you. Good afternoon, Mr. Chair and honorable members, and thank you for also inviting me to discuss the proposed amendments to the Investment Canada Act. My name is Naveen Juneja. I'm co-chair of the Competition, Antitrust, and Foreign Investment Group at Blake, Castles & Graydon. I'm also here as an individual and in my personal capacity and not on behalf of the firm or any of our clients. I have been practicing in the area of foreign investment and the Investment Canada Act in particular for over 20 years. So, as with my colleagues, I've had the opportunity to see firsthand the evolution of the ICA from before we had a national security review regime to when the national security review regime that we currently have was enacted in 2009, and to now the more recent trends of an increase in the number of national security reviews. So I wanted to make a few brief observations on the proposed legislation based on these experiences and look forward to any questions from the committee afterwards. My comments are really directed at one of the key themes that has come up repeatedly in this committee's work on this legislation, and that is how to best balance the dual objectives of strengthening Canada's national security while at the same time encouraging the investment and capital needed to strengthen Canada's economy. First, as a general matter, the framework set out in the bill, in my view, contains a number of very well-reasoned features directed at accomplishing both of these objectives. In particular, the mandatory pre-closing filings for certain sensitive sectors, if implemented properly, would allow the government to better screen for investments of concerns from a national security perspective. Additionally, the improved information sharing with international counterparts should also allow Canadian government officials to make better informed decisions on national security matters. Another useful feature, and the one that I wanted to focus on more in my remarks, is the newly proposed authority for the minister to accept undertakings, in other words, binding commitments to mitigate national security risks. In my view, this is a tool that is lacking in the current legislation and has the potential to allow the Canadian government to do a much better job of balancing those two objectives of strengthening national security while encouraging foreign investment as well. An undertakings process or an undertakings regime would allow foreign investors to remedy the specific national security concern at issue without sacrificing the entire investment in the proper cases and in the appropriate circumstances. Potential undertakings could include safeguarding or restricting access to sensitive information, restricting certain lines of businesses or customers, or other more targeted and focused remedial measures. Other countries, such as the United States, have a more robust practice of using such mitigation measures to allow to address national security concerns, and it makes sense for Canada to have a similar tool to do so. Furthermore, as we look at the proposed legislation as a whole, this tool will likely prove to be more useful and more important as national security reviews will likely become more frequent. In other words, given the recent trends towards greater scrutiny, the increased powers contained in the bill, for example, in requiring mandatory pre-closing notifications for certain sectors, one can expect a greater number of national security reviews covering perhaps a wider range of industries. So having the ability to apply a more targeted set of undertakings in a regime that substantively addresses the national security concerns at issue will likely prove to be very useful going forward in balancing those two objectives. That being said, there are also elements of the bill and its implementation that are of some concern and could be improved in order to increase its effectiveness. And my colleagues have spoken to a number of those points. First of all, the bill allows the minister to impose interim conditions on the investor prior to the conclusion of a review. This particular aspect is quite novel and expansive. And while its stated purpose is to prevent the risk of national security injury taking place before a review is complete, it also has the potential to be quite broad in application, and in my view, risks chilling otherwise benign and legitimate investments. In practice, foreign investors are typically accustomed to conditions being applied if they are needed to allow closing to occur. However, I do worry that a perceived threat of interim conditions prior to closing could actually deter investments from legitimate partners even signing on to an agreement to invest in Canada. Second of all, the effectiveness of the bill and its implementation would be improved if there were greater disclosure and transparency to investors during the national security review process. There's no doubt a need to ensure that information sensitive to national security is protected, but from my perspective, there are ways to ensure that additional information is made available generally. Such disclosure and transparency also has the added benefit of allowing current and future investors to plainly recognize government concerns so they can be addressed at an earlier stage. And finally, there are clearly a number of new and expansive elements contained in the bill. The Investment Review Division will need to be adequately resourced and staffed in order to be able to meet with what appear to be considerably greater demands to review filings, conduct reviews, and engage with investors. So in summary, in seeking to both strengthen protections for national security and encourage investment to Canada, there are a number of well thought out elements of the proposed legislation. There are also ways in which the legislation and its implementation could be improved and enhanced. Thank you again for the opportunity to present today, and I look forward to answering questions you may have.
Thank you very much. And our final witness, Mr. Crane, please.
Mr. Chair, committee members, thank you for the invitation to appear today. I'll keep my opening remarks very brief. My name is Josh Crane. I'm a partner in the Competition and Foreign Investment Group at Macmillan. I've represented many foreign buyers and Canadian businesses in connection with investment transactions that have been subject to the ICA. My comments will focus on the proposed judicial review amendment at section 25.7. I'd like to start by offering some context. All the foreign investors that I encounter in my law practice are looking to make investments in Canada because they see an opportunity to tap into an educated workforce, expand their sales channels, or find opportunities to grow their businesses. The people who I meet are genuinely interested in building successful enterprises. They are receptive to feedback and sensitive to the political environment in Canada. I also appreciate that there are state forces at work that we cannot always see. And I do believe that Canada needs to be prudent about foreign state interference in our economic system. The challenge I see is that the proposed amendments don't fix a fundamental issue with the ICA, which is that investors are not provided with sufficient information to decide whether to continue to pursue an investment caught up in a national security review or to withdraw their investment. This is a challenge for investors and their advisors because the pathway forward can become very unclear. In a paper that I published last year, we proposed that the process include the creation of a national security amicus or intermediary to help bridge the communication and information gap between investors and the government. We recommended that this amicus be authorized to review a packet of confidential evidence used to make a security assessment and then brief the investor on the strength of the government's position without disclosing sensitive information. This includes the benefit of encouraging investors to withdraw their investments before the government has to make a national security order. If the matter proceeds to judicial review, which the amendments now contemplate, the amicus could challenge the accuracy, reliability, and sufficiency of the evidence collected to ensure that the government is appropriately held to account before a court of law. The process we proposed is not without precedent. It's used in the immigration security certificate process, which also has national security dimensions. The Canadian International Trade Tribunal also allows external counsel to receive confidential information on condition they sign strict confidentiality undertakings with significant penalties for a breach. We've provided Mr. McPherson with a copy of the paper, which I understand the Canadian Bar Association has endorsed in its brief. Those are my submissions, and I look forward to addressing any questions you may have.
Okay, thank you very much. We'll begin our questioning now. I appreciate the testimony from the witnesses, and we'll begin with the first round of 6 minutes by Mr. Williams.
Thank you very much, Mr. Chair, and thank you for all of our witnesses for joining us today. It's actually great, Mr. Bhattacharjee and Mr. Hirsch. You're right on our wavelength. You must have been listening intently at our discussions at our last meeting just on these lists, who manages the lists, and how do we make the recommend changes in legislation to ensure when this C-34 is passed in the House that we're doing the bare minimum what CFIUS and the UK are doing, but how do we make it great for Canada? And again, the other side, Mr. Crane, you touched on an important part. How do we ensure we also maintain the maximum investment we can in Canada? So I think I want to focus, Mr. Bhattacharjee, on the comments you were making. I agree with you to have a list that isn't baked into legislation, that couldn't be reopened in sometimes 22 years. I agree with you that we need to look at ways to make it flexible. What recommendations can we make, or could you make from a legal perspective to the legislation that would allow, I think, at least a review of that list maybe once every 3 years? You could tell me if you feel it's different. And what we heard before was to have that done. I'm trying to remember the term right now, not in council, in governance. Governor and council, yes, but there was another term we had in governance, I think it was. So to ensure that staff, we had staff here as witnesses last week as well, but we're asking them also how do they handle that. So I'm going to start my first round with that question, sir.
Look, I'm agnostic as to whether the ability to review the sufficiency of the list is in the Act or the regs. In the UK example that I provided, that's actually in the regulation, not the Act, for whatever reason they chose to do that. I do feel strongly that the list itself should remain a regulation. I think that one of the things that we have learned, and I say this, and my colleagues and I have all been sort of at this for a while, but one of the things that we can tell you is that the evolution of the landscape since 2009, when this power found its way into the law to where we are now, really is quite something. And the preoccupations and concerns that we collectively as a nation were looking at in 2009 obviously have shifted since that time here. So I do think that the list itself, that should be left flexible in regs. I do think that there should be an ability for Parliament to sort of order some sort of review or a report on the sufficiency of that list. And I think beyond that, that's the best that you can probably do to have the balance of both worlds, right? You have a list that's flexible and the ability to go back and take a look.
And do you have a recommendation for specific wording or what section of C34 you would make recommendations based on that?
Not presently, but I can certainly send one to the clerk.
Yeah, that'd be great. And Mr. Hirsch, the other thing we've talked about is the department of which is looking after this. CFIUS is multi-agency, so it's not just one. It's not economic development. It's across the whole spectrum. And this legislation, C34, and is only on, and the RDI is only on for ISED itself. Do you think that there's a recommendation that we need to expand that, just like CFIUS does, or do you think it's okay to sit within ISED?
So I think whether it sits within ISED versus other agencies as well. First off, I think a multi-agency approach is probably the right one. The understanding or analyzing and assessing the potential national security implications isn't just ISED. There's national security apparatus. There's a whole bunch of other things. Whether it's within one agency, the most important thing that I find, my experience is that with ISED is that they don't have the national security experience in ISED, doesn't reside in ISED. So they are often sort of playing shuttle diplomacy or shuttle communication between the national security group and the investor. So I think that at the very least I would house some of that expertise within ISED, but I do think that having a multi-agency approach or a whole of government approach to assessing these things and putting the right people in the right place so that we can deal with this efficiently is the most effective way to assess national security risk and also develop mitigation strategies if those are appropriate. So I really do think that a combined approach is the correct one.
And on that note, would you have a recommendation on where that kind of wording would live in C34 for a change?
So I'd have to think about that. I don't have the ability to draft statute off the top of my head, unfortunately. I wish I did. But I think the issue, I don't know whether it's an issue of whether that should be in this legislation, whether that's really a construction of the agency. But certainly if you wanted to do that, it could be, I don't know whether that would be this legislation or some other legislation, but I really don't have a good sense of whether it's actually necessary. But if it is necessary, it should go, probably, towards the front of the legislation, but I couldn't give you any specific guidance on that point.
Thank you. Mr. Crane, you did mention, obviously, that, we've talked about a list of certain technology or critical technology that we want to protect in Canada, and certainly we want to see maximum investment to that. Are there any changes you could recommend in C34 and legislation or anything that you think needs to be removed to maximize that?
Yes, I think we should consider adding a special advocate provision to Section 25.7, which is included in the Immigration and Refugee Protection Act. There is a precedent and a model there, and if a investment goes into judicial review, we should consider having a similar process included in this statute as well. And so I would direct this committee to look at Section 83 sub 1.2 of the Immigration and Refugee Protection Act as a good precedent for inclusion in Section 25.7 of the ICA.
Thank you, MP Williams. MP Lapointe.
Thank you, Chair. My question is for Mr. Bhattacharjee. In your opening statement, you talked about the U.S.'s Inflation Reduction Act and the opportunities that presents for Canada's critical minerals and the mining sector. In your opinion, how will the updated Investment Canada Act help encourage foreign investment while also mitigating potentially harmful foreign investments in critical minerals?
I think that is the million-dollar question. And I would say that what I was referring to wasn't the IRA, but sort of our agreement with the U.S. on critical minerals. But I think the principle is the same. And it actually does go a bit to what my colleague, Mr. Hirsch, talked about in his remarks, which is, we have a system of foreign investment regulation which has a net benefit regime and a national security regime. And we have made the decision to subject fewer and fewer investments to review under the economic test within the net benefit regime. while at the same time expanding, I think, our views of the sorts of things that we should look at under national security. But even under the national security regime, as Mr. Hirsch has pointed out, it is not a situation where we have a vast number of deals that are going through this process. There are significant matters that have raised issues that have obviously progressed through reviews, but many of them are cleared after a degree of scrutiny, appropriate scrutiny, and allowed to proceed. And so I think the challenge that we have is in trying to sort of have a national security screen that allows us maybe to be a bit more proactive, to find out sort of what's happening in areas that are emerging so that we're not playing catch up afterwards after an investment has been completed. You know, we're just having a lot more stuff now that we'll have to look at in advance. And then our hope is that we don't sort of scare off legitimate investors because, for example, we have a mandatory filing policy that may reach out to an extraordinarily large number of sectors. And it's one of the reasons why I kind of wanted to bring the committee back to the UK attempt to try to put some sort of guidelines around that. And their approach, in fact, is a little wackier than ours. Not wackier, but it's much broader because it doesn't, it also technically applies to domestic deals. It's not just a foreign investment review regime. So for them, it was particularly important to have that sort of structure. I think it's important for us as well because it will help avoid the chilling effect, I think, that's implied in your question.
Are there other witnesses that want to respond to that question? And I can repeat that the question is, as Canada looks at some pretty incredible opportunities with critical minerals, how can we encourage foreign investment while also mitigating potentially harmful foreign investments in critical minerals? My next question is for Mr. Bhattacharjee as well. The bill proposes interim conditions that would allow the Minister of Innovation, Science and Industry, after consultation with the Minister of Public Safety, to impose interim conditions on investment. Do you support the need for interim conditions? And if you do, why?
So I think that the caution that my colleagues have sort of expressed in their comments is a valid one. I think it doesn't mean that we shouldn't have the power in there. There may, and I think the minister sort of explained some of the circumstances that the government is concerned about that would justify exercise of that interim power. If we do choose to proceed with that in the legislation, you know, my recommendation would be that you would want to sort of spell out, presumably, the limited circumstances within which it would be deployed, to make clear to foreign investors that there's no chilling effect, that there will only be a particular type of investment that may justify the use of that sort of power. And then that would be communicated either in guidance, if not in the actual text of the legislation itself. Although I suspect that one is more likely to find its way in guidance as opposed to something in the legislation.
Do I still have to? So very quickly, the bill will update penalties to strengthen deterrence. What is your advice about penalties for non-compliance and how these would be beneficial to ensure compliance?
Sure. Well, I think that, in fact, we're unusual in the current Investment Canada Act where we don't have significant penalties, and the penalties come only if you continue to fail to not to comply. I think that penalties, ensuring that they're of the correct magnitude, are a very important tool in ensuring compliance with a regime like this, and they need to be calibrated. So, for example, you know, it's inappropriate, I think, to heavily punish somebody for failing to file where it clearly was accidental versus potentially deliberate. I believe it may be appropriate to have a bit of a grace period before you start to impose penalties for failing to make a pre-merger filing. But I do think that penalties and making sure that they're sufficiently large is an important piece of having a robust regime and having some teeth to it to ensure that people do behave the way that we want them to.
Thank you. Monsieur Le Maire.
Merci, Monsieur le Président.
Thank you, Chair, and thank you to the witnesses.
we can sense the expertise on this panel. In the course of our study on this framework, and one point that I hold close to my heart, and I'd like to put it in context. In Quebec, we see the acquisition of various mergers. The comments made by the minister, 5 years later, it seems there's not much left in Quebec. We're not, the whole supply chain where there was a complete system has been dysfunctional for quite a bit, and particularly impacting in Quebec. Now, the question I'd like to ask each of you, do you feel that this bill, with the stakes of national security, of course, the conditions that have been proposed by the minister for accountability, transparency, comparatively balanced with the improvement that we would have with these regimes? So I'd like to begin with Mr. Joshua.
It's an excellent question. You know, I have to say that we want to be encouraging investments, particularly in Quebec. Quebec has a burgeoning technology center. It has a technology industry. It's got a fantastic aerospace industry. There's a long history of mining in Quebec. And so I agree with you, Mr. Lemire, that we want to make sure that the changes to the Investment Canada Act continue to encourage investors from around the world to see what a great place Quebec is to make investments, what a fantastic workforce it has, the contributions that the graduates of Quebec's fantastic universities are making to the economy. And so again, sir, it's why we've recommended that we want to make sure that we're protecting Canada from foreign threats and from issues of national security, but also to make sure that this government and decision makers are held to account so that they don't unduly dissuade investments to grow jobs, to create businesses, and to strengthen Quebec and other parts of Canada and the sectors that they're trying to grow.
Monsieur Janedja, voulez-vous rajouter?
Would you like to add anything else, please? Mr. Go ahead, sir.
Agree with Mr. Crane's comments. I also would add that for this particular legislation, one thing that stands out is the mandatory pre-closing filing obligation. And while I think it's important that that process still focuses on national security elements, one thing that will likely evolve out of it is a greater level of discussion between foreign investors and government officials in a wide range of areas. Because what happens in practice when the government encourages that early dialogue is, in practice, foreign investors, very sophisticated and deal with governments all over the world, like to develop those kinds of relationships that encourage that kind of dialogue going forward. And I think that is one added benefit of the mandatory pre-closing filing obligation. It's also important that it be done properly and it be done with some of the cautions that my colleagues have advised about to make sure we don't have that chilling effect and make sure there is certainty and predictability and clarity in terms of how that process will unfold. But I think what we'll see is, generally speaking, a greater level of dialogue between the foreign investors and government officials generally at the federal level and quite frankly at the provincial and community level as well.
Monsieur Hirsch,
Mr. Hirsch, I'd be interested in hearing what you have to say as to the transparency and accountability position.
So I think that there are issues that in your question that are far broader than the Investment Canada Act. I think the importance of the Investment Canada Act should be calibrated in a way, including the national security provisions, such that it doesn't deter good foreign investment that's aligned with Canadian national security interests. But I think that some of your question in terms of the fate of Canadian manufacturing or the Canadian sectors is also about creating Canadian champions. And also, for example, I know that in Quebec, the Quebec government is very involved in a strategic initiative to create a lithium value chain in the province. And I think that making sure we have domestic investment, whether that be Canadian-based companies or government-supported investment where it's appropriate, is a key piece of that much larger discussion about how to keep Canadian industry, Canadian jobs strong and can maintain control over certain assets. So I think that, and that's far beyond the Investment Canada Act. I think the Investment Canada Act's role is through the net benefit process to make sure that from a practical perspective, commercial perspective, that foreign investments are in line with those goals, to make sure that we have a national security process that is not an impediment to good investment. But I also think there's many broader issues at play in terms of fully address the type of questions that you've asked or the types of concerns that you've flagged in your question.
Merci, vous êtes.
Thank you. You've been very good at explaining this to us. My time is up, Mr. Bhattacharjee. I'll ask you my questions next round.
Thank you, Monsieur Lemieux. MP Green, you're next.
Thank you very much. Gentlemen, I'm going to put a series of questions to you in a rather rapid-fire way. I'm going to ask that you answer the first round of questioning in a yes or no fashion so I get a better sense for whom I'm hearing from today. I'm a guest of this committee, and I'm just trying to familiarize myself with it. So I'll go down the list with Mr. Bhattacharjee. Have you represented foreign companies acquiring Canadian corporations?
Yes.
Mr. Hirsch?
Yes.
Mr. Jonja?
Yes.
Mr. Crane?
Yes.
And what was the size and scope? What was the like, you don't have to name the company, but just in terms of the size of the acquisition, what kind of value did that represent? Mr. Bhattacharjee, what was the largest one?
I think, over 25 years, it's hard to give you a fast answer to that. I think there have been very large public deals that I've been involved in, and also smaller ones that have just
Just
been
give me a scope. It's a big deal, You'd probably know
ranging
roughly.
from 50 billion to smaller.
Mr. Hirsch?
Same
question.
Same as Mr. Bhattacharjee.
Mr. Jonja?
Yes, it's a wide range.
Mr. Crane?
Same with me. Yeah.
Okay, these are all big fish. Have you represented foreign state-owned companies acquiring Canadian corporations, and if so, from which country? Mr. Bhattacharjee?
I have. I have advised the Abu Dhabi Energy Corporation, I think, in the mid-2000s.
Mr. Hirsch?
I have. That's due to client confidentiality. That's all I can get into right now.
You can't tell me the country?
Oh, the country?
Yeah.
A range of countries, Asia, China, Middle East.
Mr. Jonja?
Yes, the same for me as well.
Which country specifically, sir?
The Middle East, from
Which countries in the Middle East?
From Kuwait in the Middle East.
Any other ones?
I don't recall any other state-owned foreign government.
You don't recall?
No.
Okay. Mr. Crane?
The major transactions I've worked on are actually available on my bio on my website, Mr. Green. So you're welcome.
I'm
to
asking you right
consult.
now in committee, sir, for the purpose of your testimony. Thanks. I don't feel like Googling.
Sure, no problem. I've acted for state-owned companies from Asia, from Europe, from the Middle East as well.
Specifically, which countries?
From China, from Korea, from Norway, many countries.
Okay. Have you represented foreign technology or biopharmaceutical companies acquiring Canadian companies that did not trigger an Investment Canada Act review? Mr. Bhattacharjee?
Sorry, can you repeat the question, please?
Have you represented foreign technology or biopharmaceutical companies acquiring Canadian companies that did not trigger an Investment Canada Act review?
I've advised foreign technology companies on transactions that were not subject to the Investment Canada Act and some that were.
How many that were not?
I cannot say right now. I don't know.
Mr. Hirsch?
Same response as Mr. Bhattacharjee.
You have, but you can't recall?
Yeah, I just don't keep count.
Okay. Mr. Jonja?
Yeah, the same.
I see you all have the same counsel. Mr. Crane?
I've worked on dozens of transactions, Mr. Green. I can't remember them all offhand.
Okay. Just for the purpose, as we're trying to get a sense, you've all stated that you're here as individuals, but obviously you're representing clients. Obviously, there are client interests in the framework of the act in which we're trying to find adequate amendments for. And so I'm just trying to get a sense as I embark on this from whom you are speaking from in terms of your experience. Did any of those companies that were acquired receive government funding for research and development or license from Canadian universities' intellectual property? Mr. Bhattacharjee?
First thing I'll say is I'm not here on behalf of any client interests, Mr. Green. And the
No, I
answer to your
understand that.
second
I'm not-
question is I'll answer your second question. The answer is I don't know.
You don't know. Mr. Hirsch?
No idea.
Mr. Joncha?
Yeah, I also don't recall and would just wanted to emphasize I am here as an individual.
Crane? Mr. Crane?
I don't remember, Mr. Green. I work on a lot of transactions. So it's conceivable that some of the businesses whose clients I've acted for have received some government funding.
Okay. So, in looking at some of the points that have been raised today, there is the issue, obviously, of finding out, when takeovers happen, what's going to trigger a review, what's not going to trigger a review. And I reference from 2006 to 2022, IBM purchased 17 Canadian companies. Google then bought 13. None of these takeovers of Canadian tech companies were reviewed by the Investment Act in Canada. All of them were innovative startups with significant intellectual property that was developed here in Canada. Mr. Bhattacharjee, how would you respond to that as a potential concern related to this bill?
A lot of this goes back. I'm not familiar with the pattern of transactions that you've identified, but I will tell you that initially we only had one test in the Investment Canada Act, which was a net benefit test, which sort of ran on the basis of, at that time, asset-based thresholds. And so you only had a review process that would kick in if you had a deal that exceeded asset thresholds.
And do you believe that this legislation strengthens that or weakens it?
Well, I'm going to finish my answer first. What we did was then put in the national security test to try to allow us a chance to review transactions that were not dealt with under those asset thresholds. And so that's kind of why we are where we are right now. And sorry, you had a follow-up question, Mr. Green?
I think my time's out. Thank you.
Thank you, Mr. Green. Mr. Genereux, you're next.
Merci beaucoup à tous les témoins. Vous n'êtes pas en danger. Il n'y a personne qui va vous attaquer. Soyez pas inquiets.
Thank you very much to all the witnesses. No one's going to attack you in any of your comments. We don't want you to feel that you're under the gun. Mr. Hirsch, you said that the United States had a concept, and what definition would you give to that, to technology? TID, did you say? What is it?
Regulations is a U.S. TID, T-I-D business, with the TID being short form for sensitive technology, sensitive infrastructure, and data. And that is that's defined under the regulations that are applied through the CFIUS process.
OK, donc est-ce que ce processus-là...
Does that process, can we consider it to be a way of identifying various economic sectors which would be to be verified perhaps very closely? In Canada, of course, do we have an equivalent? But your colleague was saying that the description of these sectors of activity was poorly or insufficiently defined or categorized. Is the American system or classification better than Canadian?
I think the two things. One, it is in a regulation. All we have are guidelines on the application of the national security review provisions. The guidelines are non-binding. They are very high level, and so I think that if we are going to, and I think we should, if we are going to provide much needed clarity and transparency, we should adopt something similar to what's been done either in the U.S. or perhaps in the U.K.
Monsieur Bhattacharjee.
For Mr. Bhattacharjee, your intervention was excellent. I'm thinking in today's society, with the development of new technology, is very, very fast. When we take a look at AI, for example, well, in the tech world, it's like using a bulldozer, I guess, and just picking everything up. how do we define within a bill, even if as an annex or a schedule, a technological sector, which is emerging technology, but it's taking up a lot of room in society. In 10, 15, or 20 years, we may have a potential identification of some of these acquisitions. Would you suggest that we could review the definition every once in a while, whether it's annual, triennial, so that we can adjust to the progress of this technological advance?
I think it is absolutely the case that we want the ability to revise that list frequently. I think the only counter argument to that is that if you revise it too frequently, it reduces certainty to investors. And so I'm sure for one reason the CFIUS process, the UK process, they review it sort of on a multi-year basis as opposed to every year. But I agree that there's a balance. And the other part of this is that our process under the Investment Canada Act is sort of only one way where the federal government can be aware of emerging trends and things of concern. And so we also have the benefit of that part of it to help tell us that these are sectors that are emerging that we may need to protect or watch for developments, including foreign investment.
Au niveau, les autres témoins, est-ce que vous auriez quelque chose?
Would the other witnesses have something to add on that particular subject? Annually, or go ahead.
I think there's an opportunity for a feedback loop in terms of how the list is updated, how often it's updated. And I think the idea of having greater transparency, whether it's through supplements to the annual report in terms of how many of those sectors that have been identified are actually leading to extended reviews or national security concerns, and having that, at least in an aggregated way, disclosed provides further information that can help keep the list updated.
Je sais pas, vous avez sûrement regardé un peu les réunions précédentes.
I'm sure that you've been following our committee diligently or known what we've been discussing. We had a witness come forward and say we were very, very much behind and late the law, the way it was drafted vis-a-vis these new emergent technologies in particular. Would you agree with that general statement explained by Mr. Mazzilli?
I think that there is always a challenge in the government and oversight keeping up with the pace of technology. I think that is a fair statement and a fair issue that has to be confronted. I do think at an overall level, there is the ability to try to keep the list updated. And I agree with Mr. Bhattacharjee that if you do it too often, it does reduce the uncertainty. But that's where the additional transparency, the additional disclosure, and the feedback loop in terms of that information can be helpful as well.
Considérez-vous que
would you consider that Canada, technologically speaking, AI in particular, I'm quite interested in that, but it's evolving so fast that it's going to really dislodge and upset society in a few decades. Do you think that the Investment Act, the fear that technology or some of the elements that it contains, such as AI, will be taken, would be looked at more closely, and perhaps investors would be prepared to invest here in Canada? Is there not a danger that this bill is sufficiently robust to not be overtaken by what's happening in other countries?
If I understand the question, I think the bill is an important step forward. I think it tries to do a good job of balancing those concerns with advanced technology together with the need to continue the investment so we have the ability to develop that technology in Canada as well and then protect it. So I think the bill does try to do a good job, but the implementation of it in the details, I think, is going to be important as well.
George?
I think that Canada is a little bit behind. I don't think it's so far behind that it can't catch up. I think the issue from a national security perspective isn't so much the impact of AI on the Canadian economy or individual Canadians, but rather making sure that to the extent that we develop AI in Canada, that it's done in a way, or the investment in that is by people who are compatible from a national security perspective. That's sort of the limited role I see for the Investment Canada Act. There are much broader issues with AI that I think are outside the ambit of the Investment Canada Act.
Thank you. We've gone a little long. MP Van Bynen.
Thank you, Mr. Chair. I was interested in the comments made by Mr. Bhattacharjee with respect to the UK's approach to sensitive sectors. I think you referenced there were 17 sectors identified. That also had a regulation. That also had a guideline. In getting more defined, would that not constrain the authority, the reviewing authority, and how would we overcome that?
Very good question. And when we refer to sort of the situation we have now, we have to cut ourselves a bit of slack, because the reason I think the government wanted those technologies and areas to be sort of stated broadly was because you had to sort of look at all of the potential relevance of that to a determination of a national security issue. The problem is that once you put in a system that requires investors to do something in advance, and then with the risk of sanctions if you fail to comply, you kind of do have to spell it out a little bit more clearly so that people know what they're responding to, where they think they've got an issue, and where they may need to engage the government. And so I think that, although I take the point that spelling it out in detail may exclude things, I think on balance, when you're asking people to come in mandatorily before and then engage with the government, you kind of do have to have that clarity so they know what they're doing.
And I believe it was Mr. Hirsch who referenced concerns about the skill sets that were in the innovation group.
I'm not suggesting that the folks who are employed or staffed at the IRD are not very qualified. What I think is that they have a particular skill set, and that to make the IRD more effective, if the IRD is going to have a bigger role in assessing national security issues, is to ensure that additional capacity and capabilities are brought to the IRD. I believe the question was, should it be multi-agency or should it be IRD? And the key is that there should be a group of people who can assess this housed under the same organization or working in tandem, perhaps more so than they are today.
Would you suggest that the minister be required to consult with other stakeholders such as Canadian Security Intelligence, the Mounted Police, Canadian Security Establishment in the national review process?
So the minister is already required to consult with the national security apparatus in assessing whether a transaction could raise issues. I think the issue is that right now, again, I'm not an insider, but the perception is that sometimes there is a bit of a disjoint or disconnection between the two, and that perhaps the process, because of that, is not as efficient as it could be. Again, that is an outsider's view of based on perception as opposed to how the system works in reality.
Should be there. I'd like to come back to the UK's model one more time, and that is, you'd indicated that it also reflected acquisitions internally. And so what was the criteria for that, and to what extent would that benefit Canada, and should that fit inside this legislation?
I thank you for letting me correct my view that the process was wacky. It is not wacky. It is a choice that the UK legislature has made because they believe, I believe, that national security issues can arise in the review of domestic transactions. I'm not really aware of the other circumstances of why they've done that, but it is just a very different approach than what we've chosen to do here in Canada.
Would there be concerns about industry concentration, those type of things that could be created internally?
I can't comment further on sort of the thinking of the UK government on that.
Okay. So have any other countries amended their foreign investment regulations in recent years that we could still learn from, in addition to what you've highlighted? Is there anything that you'd like to add to your comments?
if I can just sort of follow up on that, one jurisdiction that gets a lot of attention, I think, in Canada for regulatory sort of policy is Australia. And Australia, like Canada, was fairly early in the game in terms of examining inbound investment from an economic and then later more of a national interest or national security screen. And so I'm sure that the experience of our Australian colleagues under their FIRB regime no doubt has been taken into account by folks both proposing the bill and probably within industry.
One more question for all three, or for all members here, is would the amendments in Bill C-34 adequately protect us for intangible assets, such as the intellectual property from foreign investments that could be injurious to national security? And if not, what recommendations would you make to compensate?
Anyone that's your choice, I guess, who wants to answer?
With Mr. Bhattacharjee? Mr. Bhattacharjee?
It's a step. I mean, if you take a look at how we approach this, pre-2009, that stuff was clearly not covered by the review requirements. So we add sort of a test in that's designed to allow more flexibility in the type of investments that the government is allowed to scrutinize. I think probably at the moment it still is the case, as I read the bill, that it requires sort of certain threshold structures to be in existence before the review requirement can kick in. So I think, it may be the case that certain types of intangibles are not caught by the bill. I mean, I don't know, I haven't thought about that, that carefully. But I would also urge the committee, again, not to think that the Investment Canada Act is the only way that we can look at or address those concerns. Like, we do have other sort of federal mechanisms in various areas which do allow for some degree of scrutiny. So I just don't think we have to pack it all in the Investment Canada Act. Even if it isn't there, we may have other ways that we can use deploy to protect those interests.
We've gone a little over time. Monsieur Lemur.
Merci, Monsieur le Président.
Thanks again, Chair. It's good. We have to respect your authority here in the committee and the timelines. Mr. Bhattacharjee, I'd like to come back to the issue of transparency and accountability in these transactions on Investment Canada Act. National security, of course, and net benefit, see what we can balance there. Could we go a little bit further and make more improvements to the Act?
I think, first of all, I'm going to focus my comments on national security, not net benefit, because the amendments that we're really talking about here are focused on the national security test. But I do think you raise a very, very good question, and actually the question coming, with respect to, for example, Quebec's own involvement, significant involvement in the EV chain, in critical minerals. I mean, it does mean that Quebecers have as much interest as they should in ensuring that foreign investment rules apply so as not to scare away legitimate investment, but also protect the position of Quebec entities that are involved. And I know it's funny because you've got 4 lawyers here talking about technical stuff in the Act, and almost all of us are talking about very procedural sorts of things. But it is exactly the procedural issues that we have raised that will help provide a little bit more transparency, certainty, and stability, but at the same time sort of allow the government to step in where it believes necessary. So I chose to talk about sectors. And the sector is important because we need to know what the government will get an advance look at. And then my other colleagues have talked about other changes that will maybe increase transparency, have a judicial review function. All those things combined mean that you have a better balance between encouraging investment, but just if you get the procedure right, making sure people feel that if the national security process is being deployed, it's done in a way that's done appropriately and doesn't scare away legitimate inbound investment.
Merci beaucoup. Je vais m'arrêter là, Monsieur.
Thank you very much. I'll come back on a third turn, Mr. Chair. Thank you.
Okay, Mr. Green, you're next.
Thank you very much. Mr. Jonja, in your opinion, based on your understanding of this bill, if a Canadian company is taken over by a foreign investor and is approved by ISED, if that foreign company is then taken over by a state-owned company, would the new reforms in the bill allow the minister to force divestment or any further undertakings afterwards?
They would. They would allow the minister to review that investment and to, if the process unfolded that way, conduct a national security review, and then the specific enforcement measures that the Act allows for could be deployed.
And in your opinion, is this robust enough to protect against any potential kind of takeover from a foreign state actor?
I think it is a positive step forward in terms of strengthening the national security review process as it relates to a variety of types of investments, including the example that you mentioned.
Mr. Crane, in your opinion, if a takeover is proposed for a Canadian company that has received government funding to develop technology, would these reforms allow the minister to claw back that intellectual property?
Quite possibly, Mr. Green. That is one of the conditions that the minister might be able to impose on a foreign buyer. And we've seen recently that universities, I think, are also being much more prudent about the contracting practices that they're engaging in, and the government as well. And so there are opportunities in those contracts to put change of control provisions that would allow the government or a university to exercise its rights over intellectual property prior to a takeover transaction. And so there are other commercial ways that Canada and our universities can protect our intellectual property in the event of a foreign takeover.
Sorry, just so that I'm clear, am I to understand that it should be in the contract, or would the minister have the ability to claw back?
I'm saying both options are available, Mr. Green. The minister has that prerogative under the new statute, but universities and the government of Canada could also ensure that in their funding contracts, they have the commercial rights available to them to make sure that they own the IP that is jointly developed, or to ensure that they receive the payout of funding either prior to closing or before closing. And I wanted to address one more point you raised earlier, because I think we've left it hanging on the acquisition of small tech companies. There are other government bodies that review those transactions or could review those transactions. The Competition Bureau of Canada does have jurisdiction to review takeovers of small businesses. And, there is a consultation process underway to look at changes to the Competition Act that may address some of the concerns that you raised in your questions, Mr. Green. So perhaps, if this committee convenes a session on Competition Act reform, those are some of the topics you may wish to raise there as well.
Thank you.
Thank you, Mr. Green. Mr. Viss.
Thank you, Mr. Chair. Mr. Bhattacharjee, according to a recent Border-Ladner-Gervais article which you co-authored, Investment Canada aims to protect national security, how to enhance foreign M&A success. I'm going to quote you, mergers and acquisitions are now much more likely to be blocked by the Canadian government if they seem to impinge on Canada's national integrity, and may be blocked simply because of the potential buyer's country of origin. Further, it notes that with the proposed legislation, Canada will also likely target big data, artificial intelligence, significant intellectual property, and other strategic industries. So can you provide some examples of cases where the country of origin might be the deciding factor?
The guidance in this has already come from the federal government. So we already have a policy which basically restricts, if not prohibits, inbound investment from Russian entities, at least under the Investment Canada Act process. Now, there are a bunch of other sanctions regimes and stuff that also govern that, but Russia is an immediate example. So that's just one example that comes to mind.
In the same article, I'm going to quote you. It says, investors, company management teams, and boards are finding it difficult to properly assess the risks of a deal and are subsequently being subjected to government rejections with little, if any, explanation. Do you think there needs to be greater transparency when deals are rejected? And secondly, how does Canada's approach to providing explanations compare to other jurisdictions?
So I'm going to take the questions in reverse order.
Please.
Although we have had this process since 2009, I would say that in comparison, at least in my experience, and my colleagues may feel differently, but in my understanding in comparison, for example, to the U.S., our process is probably a bit more black box in terms of communicating concerns. Now, that is reflective of how we have set the process up and how we have set up the consultation with public safety. And so again, that just may be a decision that we have made. I think in some areas we are probably not as detailed, but in others, we talked about the UK as an example. I'm led to understand that when you apply under this process under the UK, you even just do it through an anonymous box. So like I just think that each jurisdiction seems to have its own approach. In some aspects of dealing with a review, we are more black box than others.
Okay, thank you. How much time do I have left, Mr. Chair?
2.5 minutes.
Okay. This question's open to anyone. In June 2020, in his testimony before this committee, he also recently appeared. Charles Burton from the Macdonald Laurier Institute stated that some enterprises controlled or owned by a foreign state, and I quote, use multiple firms with multiple investments to get under the wire of our thresholds, but they actually violate what I would regard as the intention of our act. So my questions are, do the amendments to the Investment Canada Act address the concerns raised at that meeting? Yes or no? Or why not? And how would the enactment of Bill C-34 affect prospective acquisitions of Canadian businesses by foreign state-owned or state-controlled enterprises?
Whoever wants to go first.
I'm happy to take a cut at that. Prior to this bill, a filing was mandatory if there's an acquisition of control. When you're dealing with a target corporation, that threshold can be as low as 33.3%. So you don't actually need to own a majority of the voting shares of an entity to trigger a filing requirement. But even in the case of acquisitions below 33.3%, the government has the ability to call in an investment that on national security grounds. And in fact, there was a change in the law last year that allows the government to do that for up to a 5-year period, unless the investor goes in and files a voluntary form and seeks preclearance of that investment. So really, the problem that Mr. Burton had identified was largely fixed in the last round of investments, last round of amendments to the ICA. This particular proposed bill creates a second layer of notification requirements, and that is when you have a minority transaction, but it's in a prescribed sector, there will be a mandatory filing. And my colleagues have spoken about that at length, so I'm not going to reiterate what they have to say. But just to go back to the point I made earlier, there was no sort of using disparate pieces before. As soon as you have an acquisition of control, you had a mandatory filing. And now we've got a voluntary process that allows minority acquisitions to be notified early so that other investments get caught.
Thank you, Mr. Chair.
Mr. Gahir.
Great. Thank you, Chair, and thank you to all the witnesses for making time for the committee and for your testimony. My first question is a bit of a precursor question. It's two parts. First is, what can Canadian companies and non-Canadian investors do to ensure that the investment screening process is as efficient as possible? I'll ask that one first, and then second part. Anyone?
I'll start. One of the things that the government requires in this process is the provision of information, both sort of upfront in terms of what's required to start the process going, but more importantly, as a review, if a transaction is subject to review, as that continues, there often is a back and forth, both from the investor and to ISID, for example, where questions are asked and answers have to be given. Now, the amendments actually sort of formalize that process a little bit, but even not looking at what's in the bill, most foreign investors that are trying to do this efficiently are those that can answer those questions fully, completely, and like quickly. And they tend to, I think, have a much more productive process in review than others that don't do it that way.
In line with that, with the investment screening process and doing it as efficiently as possible, has the federal government provided sufficient guidance in this regard? And is there additional information that the federal government could provide in order to improve this new process?
Yeah, I think that the government has improved its guidance historically, but I still think that there's probably room for further improvement. It's difficult to come up with guidance, but I think that if you look at sort of jurisdictions like the UK, Australia, and the US, certainly my view is that they have far more and more detailed guidance than has historically been the case with regard to the Investment Canada Act.
So I think this has been brought up a couple of times with witnesses pointing to other countries, but can any of the witnesses, for our educational sakes, come up with any specific points of what guidance we're not providing that other countries do provide? Any examples of that?
The identification of the sectors, my initial remarks sort of were really directed at that, so I would suggest you, if you're interested, you might want to take a look at those.
For example, here is a 33-page national security guidance document from the Australian regulator. So it's
Perhaps
they
you
have
could
very
just
detailed guidance.
table that with the committee and we could
Yeah.
have it for the record.
Sure.
Thanks.
Thank you. We know that Bill C-34 will also allow the Minister of Innovation Science and Industry to disclose specific information regarding national security reviews to foreign states. What are your views on this approach? Do you think that it will adequately facilitate collaboration and information sharing between countries to combat national security threats? Would you amend this part of the bill in any way? A couple of questions in there.
So I'll start. I mean, I think the reality is for those of us who've been involved in these reviews for some time, there is a degree of international communication that already goes on in terms of the review, at least on the national security side. And a lot of that is particularly acute where it's an investment that engages the interest of Five Eyes. What I think the amendments really try to do is to formalize that process and to some degree maybe to address at least a question that I heard earlier today about what happens if you might get an investor that's trying to sort of do different things in different jurisdictions. This sort of information exchange protocol, I guess, will allow us to communicate to try to manage some of those situations in a more effective way than is currently the case.
Chair, how much time do I have? A minute? Okay. So, give or take? Okay. So we know that the minister has said that with Canadian businesses and how we attract investment in this country, it's the stability and predictability that he would say that in the rule of law, that's very important for investors to know what's going on in the country. In your view, how has the proposed legislation, or how will it impact the competitiveness of Canadian businesses, and in particular for those businesses that are looking to secure additional investors?
As I've said, sir, I think the rule of law is really important, and my comments have really focused on the rule of law. One of the downsides of the proposed bill is that it allows for secret proceedings to occur in federal court regarding national security issues, and investors really don't have an opportunity to test the sufficiency or the reliability of the government's evidence. And I don't propose that we give national security information to investors directly, but I do believe that we have other tools available that we already use to make sure that investors are given due process, and that investors believe that Canada is a fair place to do business, and that if decisions are made on the basis of national security, that they have an ability to understand why.
Great. Thank you.
So that concludes the formal rounds, and I will do a sort of Joel Lightbound here just in case there's anyone else that wants to ask a few questions before we let the witnesses go. And I want to thank the witnesses for their fine testimony on this important bill. Monsieur Lemire, do you have any?
J'ai toujours des questions.
Well, I always have questions, but if I'm the only one, I think I will just bend to your suggestion and make no opposition.
The only one.
For your testimony, very much appreciated. Oh, did you say, sorry, Mr. Green, did you have something?
I did have one
Sure,
quick
go ahead.
question. But I would concede to my friend from the block if he wanted to put his question first.
Go ahead. Go ahead, Mr. Green.
Okay, thank you. This question is for Mr. Crane. national security concerns could be very difficult to fully identify. Certain technologies which are in consumer space and companies develop them are focused on consumer purposes. But these same technologies can be redeployed in defense systems such as AI or facial recognition. So, or even cyber weapons development. So how would you address the potential dual use of technologies, such as I said, establish an expert panel, or like what would be some of your inputs?
It's an excellent question, Mr. Green, and I thank you for raising it. And actually, it's one of the biggest challenges that advisors have for investors, because investors may be believing that they are buying a business or investing in a technology for perfectly benign use. But that technology, as you know, could have military or other applications. And that's where the gap often lies in these situations. And so, my advice to the government is that trying to resolve that gap early is going to be helpful for both sides. Either the investor knows, look, I'm not going to do this because there is a risk that this technology could fall into hands that we don't want, or there's an opportunity for the government to understand the investor's position and possibly put some parameters around where this technology is going to go. Are there aspects of the technology that could be licensed or sold that are not problematic? Are there ways that the investors could shift investment into Canada so that we become a leader in that technology? So I agree with you, Mr. Green. Like, that is the problem. And finding ways to bridge the gap between the investment community and the government is the fundamental way that we can increase investment in that space and avoid the embarrassment of having to tell investors, I'm sorry, but you can't invest in Canada.
Thank you. And I think Monsieur Lemieux has one.
Merci, Monsieur le Président. Je vais le faire parce que...
Thank you. Well, I just reread the question, and I'd be interested. Mr. Hirsch, you know that Temiskaming is a mining area. I think you're interested there. Last week, there was a Windfall Cisco in the north of Quebec, which gave half of its project to Goldfield, sold for $100 million. So it'll be 50-50 co-ownership. We're seeing that more and more in the mining sector. We're talking about gold in this case, but this is a type of partnership which is becoming more prevalent. Do you think that once it's settled, do you think that external, if they can decide to conduct an agreement with another country, a country which is perhaps like China, for example, more high risk, could something be triggered here where we could go back, perhaps retroactivity or not, but to apply this new bill?
It depends on the interest that the non-Canadian has, but I think that this, well, and again, the gold is not a critical mineral, but I believe that if the acquisition of control or the non-Canadian stake in a Canadian mining operation in many cases would be or could be subject to the Investment Canada Act, whether that be the general provisions or the national security provisions. And I think that the Act and especially with regard to, say, something like the lithium industry, that certainly these provisions do assist in that regard in terms of making sure that a joint venture with a trading partner who is viewed as safe from a national security perspective is potentially prohibited from being taken over, that interest being taken over by somebody where we believe we have that raises national security concerns. So I think that in many cases that would be subject to the Investment Canada Act, either under the new provisions or the existing provisions.
Merci, Monsieur le Président. Merci.
Thank you, Chair, and thank you to the witnesses.
Mr. Chair, thank you for allowing one additional question. I have a question for all three, but I'll start with Mr. Hirsch. And a big part of the consideration in evaluation is including intangibles. Is there a discipline that you can validate the intangibles in order to determine that it fairly reflects the value that's being exchanged? Is there a discipline that's accepted in the industry?
So that's a challenging question because in many cases it's actually an accountancy question because it depends on different companies book intangibles differently. Sometimes they're booked as an asset. sometimes they're booked as an asset that, at a fairly low value. And then there's also the notion of fair market value. So if you were asking me which is the correct approach or that might better capture intangibles, is probably a fair market value approach versus potentially a book value approach if we want to set thresholds.
How's that fair market value determined?
Well, again, that's an accountancy question, but generally speaking, it is basically often for the purpose of the sale or it's the transaction value, which will be a more realistic, in some cases, assessment of fair market value than perhaps a low book value, or in many cases, companies often have to prepare reports or do a detailed accounting prior to engaging in a sale, or the purchaser may do a fair market value assessment of the intangible assets.
And is that a discipline that you'd like to see in ISED as well?
So I think, again, this is different from the national security provisions, which would apply to sectors regardless of the value. This is more of what might trigger a net benefit review in terms of that. But I think that in many cases, the enterprise value test that's used under the net benefit test, the thresholds, does in many cases or probably captures the fair market versus the book value of the assets. In fact, that's why the enterprise value threshold was introduced. But what's interesting is that the thresholds applicable to state-owned investors are asset-based as opposed to enterprise value-based.
The other members?
Any other witnesses like to comment on those questions, the ones online in particular? No. No, apparently not. So thank you, witnesses. I appreciate your testimony before the committee. I'm sure I speak for all the members. Thank you for coming in. And if you'll bear with us, we're going to switch over to an in-camera session for a few moments. It'll take us a few moments to do some committee business. Thank you again.
Thank you very much, Mr. Chair.
Thank you.